All right. All right. We are online now. Good afternoon to all of you again. And thanks for taking out time at the middle of the day, at the working hour. So today we'll be having our first labor dialogue of this year. As you already know, many of you already know, we have been organizing these labor dialogues for last 4 or 5 years. That is CEC in collaboration with RLS, where we talk about the different contemporary challenges faced by the trade union movement and labor in general, not only in India but also in our neighborhood. So we have a very distinguished panel of speakers that we have today with us. But before we move forward, I would like Lokesh to speak a few words to all of us. Lokesh is the Executive Director of CEC. Yeah, Lokesh, please.
Yeah. Hello.
Yeah.
Thanks, Mayur. Hello and welcome to everyone. Let me give you a brief intro about CEC and the Labor Dialogue series. CEC is a labor resource center that work with workers and a small producer. We focus especially on the informal workers, and we are not a trade union, but we assist the trade unions and labor organization in building awareness about the right and entitlement of the workers. For the last 3-4 years, like from 2020, we have been organizing a series of labor dialogue on the various issues and problems faced by the workers today. In that, we invite trade union leaders, labor historians, labor experts, representatives of industry bodies and government representatives also to discuss and find common ground of action. We have so far organized discussions on the impact of COVID on different sections of the workers, such as garment workers, tea plantation workers, app-based workers, etc. We have organized discussions on labor code and the different social security schemes and initiatives. In last year, we have also organized a discussion on the challenges faced by the labor movement across the South Asia subcontinent. All our labor dialogues are compiled in the form of a booklet annually. We will share the link here in chat box. You can also watch our previous labor dialogue in our YouTube channel. So we are also thankful to Rosa Luxemburg Stiftung for supporting us this whole process, this labor dialogue process. Regarding the topic that we are going to discuss today, I have only one brief point to make here. For last
Lokesh, you are muted.
Yeah. Last many years, we have been trying to assist trade unions or worker organizations to organize supply chain workers in the garment sector in Delhi, NCR, especially Gurgaon, near Gurgaon industrial area. From our experience, we can say that it is very difficult to organize these garment workers without first intervening in the upper layer of the chain. So, the local firms themselves face a lot of market-based uncertainties and insecurities. It is true that the worker bear the major burden of all such uncertainties, but at the same time, It cannot be denied that decent work can be ensured for the supply chain worker in the lower node on the chain only by intervening throughout the entire chain. So in this context, it appears that the German Supply Chain Act provide us with some opportunities because it at least theoretically talk about the interventions throughout the entire chain. I hope that we will learn quite a lot about the Act today, its potential and its limitation in today's discussion we'll find out. And I thank all our speakers and all the participants for taking out time for their busy schedules. We especially thanks to Rajiv Kumar from Rosa Luxemburg Stiftung. Rajiv has been guiding us in organize these labor dialogues from the last 3-4 years. Thank you very much.
Yeah. Thanks, Lokesh. Now, I would like to invite Rajiv Kumar to speak a few words with us. As Lokesh said, he has been guiding us throughout all these years about how, in terms of organizing these labor dialogues. Rajiv. Your mic is muted, I think.
Am I audible now?
Yeah.
Okay. Yeah. Thanks a lot, Lokesh and Mayur, for a very kind introduction to the cooperation between Rosa Luxemburg Stiftung and CEC, and especially this series of labor dialogues which we have been organizing since 2020. And this is the first labor dialogue of the current year, and on a very apt topic of German Human Rights Supply Chain Due Diligence Act, and how it is to be seen how it promotes due diligence and decent work for supply chain workers in India, South Asia, and also in the global South. I will only speak a few words because we have three eminent speakers, and we are also a certain time has passed now. So we are all aware that there are millions of workers in India, South Asia, and the global South which are engaged as supply chain workers, and there are several kinds of tiers of work, and accordingly tiers of workers and work conditions as well. So we through such labor dialogues try to engage with all kinds of tiers and nodes. But of course, our greatest concern is with regard to the lowest tiers and the weakest links in the supply chains. This labor dialogue has been a very good medium for cross-learning dialogue between stakeholders, and hope that we regularly bring and apply the learnings in effect, which we learn from here at the ground, at the grassroots, where actually it's supposed to effect changes, etc. So there have been several instruments to work on the subject of supply chain work and the workers, their conditions, wages, human rights, environmental abuses, etc. So one such instrument is the newly done German Human Rights Supply Chain Due Diligence Act. So looking forward to today's episode of the labor dialogue and learn about the nuances and the details of this legislation. And though it's a very short time, because it has just been effective since January 2023. So as I said, there are three distinguished speakers, and Nadia Dorschner, she heads the Rosa Luxemburg Stiftung in South Asia. So she is also one of the speakers. So we are all looking forward. I will just briefly mention, actually most of us here are aware that RLS it's a German political foundation, and it's a left German think tank. So there are websites, there are social media handles, channels one can visit to learn more about it. So thanks a lot. Over to you, Mayur.
Yeah, thanks, Rajiv. We have three speakers today, and all of them are experts in the field of supply chains. So we have Nadia, Gina, and Professor Dave Nathan. So we have kind of slightly made a kind of division of labor between all the three speakers. First of all, I would like to request Nadia to maybe give a somewhat a description of the political process, the political background of this act. Over to you, Nadia. Yeah.
Thank you so much, Mayur. Thank you, Lokesh. Thank you, Rajiv. I will be sharing my screen, and maybe you can give me a short thumbs up once you see it. Yes?
Yeah, we can see.
Yes.
Okay, so yeah, as Mayur said, I will start with a basic introduction to the German Human Rights Supply Chain Due Diligence Act. And I will also kind of cover the political genesis of a legislation like that. And we'll go into some developments that have been happening on the international level, but then also the process in Germany that led towards the act. I will also briefly talk about a few criticisms that are actually there to the idea of business and human rights, and then go a little more specifically into concerns that the left, but also civil society in Germany still have with the law which is in place now in Germany. So what is the German Human Rights Supply Chain Due Diligence Act? So basically, it is a legislation to regulate business activities along supply chains. And I think what is very important to mention is that the bodies that are targeted, or like the who is requested to act according to the law, are corporations, are companies. So the Human Rights Supply Chain Due Diligence Act requests companies to comply with certain human rights and environmental due diligence obligations, which are, for example, complying with the ILO core labor standards or with the International Covenants on Civil and Political Rights and Economic, Social, and Cultural Rights. So to maybe just name a few examples, and I think Zina will go deeper into this later on, but to just name a few examples of violations that are covered within this supply chain law. This is, for example, forced labor. This is any disregard to the freedom of association that can be seen along supply chains, that can be the denial of paying fees and wages. So these kind of violations are being covered in the law, and companies are required to act in a way to prevent the risks of these happening. So basically, what is required from the companies is a sort of risk management. And to give you a few technical data regarding the law, so Rajiv has already said that it is still a quite young law, so it is in effect only since January of this year. And that is also why it is somewhat difficult at this very moment to assess or to actually say how much it will help workers, how useful, how powerful a tool it will actually be. Like, it is a bit on us also to test this right now. But yeah, it has been in effect since January 2023. And before that, of course, there was a longer process of negotiating it, and it has been passed in Parliament in June 2021, actually. And it is applicable to companies in Germany. Actually, German companies is a little unspecific because it can also be like companies who are only registered in Germany, who have more than 3,000 employees. So for these, it will be applicable from this year onwards, and then from 2024 onwards, it will also be applicable for companies with more than 1,000 employees. To give you absolute numbers, that means actually these are rough data that are provided at the moment. So at the moment, it is applicable to around 900 companies in Germany, and from next year onward, it will be applicable to around 4,800 companies in Germany. And then one important body that I think should be mentioned is the Federal Office for Economic Affairs and Export Control. So this is the German authority. The short name for this is BAFA. I'm mentioning this because Federal Office for Economic Affairs and Export Control is quite long. So this authority will be the one responsible to accept complaints and to actually monitor the activities of the companies. So they are the implementing authority. Concerning the political genesis on a more global level, I think it's important to mention that there have been movements or claims for the enforcement of human rights along supply chains already since the 1980s, and they have become stronger also with the further our economy got globalized. But then things really started moving after a few very drastic human rights violations that happened along supply chains, which I think all of us here are familiar with. Those are such as the collapse of Rana Plaza, such as the factory fire in Karachi. So after these catastrophes, after these events, there was actually, things started getting a bit more concrete, and especially at the UN level, there was then a move towards negotiating the so-called UN guiding principles of business and human rights. So I will just briefly go into a few of these things that are happening on an international level. I don't think we can discuss them here today in detail because we want to focus on the German supply chain law, but I'm just mentioning them as they have sort of led up to also what has happened in Germany. So one is the United Nations Guiding Principles of Business and Human Rights. I think one important thing that is to mention there is that that is a voluntary tool that is sort of aimed at advising corporations to transform themselves and to implement voluntarily more effective strategies to minimize their risk in supply chains. Another one, another tool that reacts to the criticism that the guiding principles are voluntary are the ongoing negotiations on a UN binding treaty on business and human rights. So that is something that is not yet closed. We're seeing continuing negotiation rounds. Another tool that is in place are general framework agreements. So these are basically agreements that are in place between multinational corporations and global union federations. It's actually also a rather old tool, like the first general framework agreement was already passed in 1988. So they also try to ensure fundamental rights of workers, no matter where these workers are employed. But here again, the problem is that they are legally non-binding and voluntary, and also they are lacking mediation and arbitration procedures. So then again, something that reacted to that, and which is a more effective tool, are enforceable brand agreements. Like I think we're all familiar with the Bangladesh Accords. So that's something that was passed or negotiated between 200 lead firms and two global trade union federations, Uni Global and Industrial, along with Bangladeshi trade unions. So here again, the good thing about that is that it is a legally binding agreement, and it commits and it forces the companies to actually commit and to enforce fire and building safety. So all of these things are sort of the predecessors to the national due diligence laws that we see now, and we see them in different European countries. So you see this a nice little iceberg here. which actually also describes that the due diligence acts that are being passed in European countries, they have a different degree of strength or a different degree of things that they can tackle. And the German Supply Chain Act is one of them, and we'll get more into this in a little bit. I would like to continue just with sharing a few critical thoughts on the whole idea of business and human rights as such, just because I think this is a debate that is sometimes a little bit neglected. It is mostly a scholarly debate, and I want to emphasize also that this debate is not being held by people who oppose the idea that human rights need to be enforced along supply chains, quite the contrary, actually. But it is more like this debate is more had by people who question whether legislation is a sufficient tool, like legislation and agreements are a sufficient tool to actually change the situation of workers along supply chains. So I think the question is, do we need to accept that business is a natural phenomenon and that corporations are powerful and that we need to regulate them? Or do we need to acknowledge, first of all, that there is a power asymmetry in the global economy, because there are certain actors, which are mostly the corporations, who are actually in a position to dictate where they want to buy, when they want to buy, and also mostly at what price they want to buy, as I think we're all familiar with the concept called the race to the bottom, and like the competition also that exists between different production countries. So the question is whether due diligence laws are actually maybe legitimating the status quo of these asymmetries in the global economy, and then also the question is whether corporate accountability is something that is maybe facilitating and stabilizing the corporate profit making. So unfortunately, it is an inherent thing in capitalism that risks are being taken by corporations. Like they know that with their business activities, there are certain risks that come along, and I think we need to make sure that all the remedies also that we are asking for are not only taking care of the excesses of exactly that corporate risk externalization. So there are actually certain benefits also with business and human rights legislations for corporations. It gives them a certain legal certainty. It is good for their reputation. And also what I think we need to be careful about in future with these kind of legislations is that it cannot be enough for a corporation to show that they can tick certain boxes. So there is a potential risk of a tick the box approach. So corporations just say, yeah, we are fulfilling all these compliances. So if there are still violations now in our supply chain, then these are not our fault. So I think these are just a few things that I would actually be happy to discuss them further with you, and maybe we can keep them in mind for our discussion. But like, despite it being great that there are now legislations that regulate business activities along supply chains, we should make sure not to forget that actually it is crucial that we question the system that produces corporate abuse and that produces these violations that we are seeing. So now getting into the details of the German Human Rights Supply Chains Due Diligence Act. So the history that led to this actually was that Germany had implemented a national action plan in 2016, which was the tool that was supposed to implement the United Nations guiding principles on business and human rights. And again, here the problem was that everything that was put forth in the National Action Plan was voluntary for companies to comply to. But fortunately, one thing that was ensured in the National Action Plan was that it was continuously monitored and evaluated. And actually, an evaluation of the National Action Plan in 2020 showed that more than 80% of German companies who have more than 500 employees did not comply with the requirements of the National Action Plan. And that was then the moment where it was decided, okay, this voluntary National Action Plan is not enough, but we need a binding legislation, we need a binding rule. And yeah, what I also want to mention here is actually that the whole process of negotiating, drafting the German supply chain law was continuously accompanied by a very big coalition of civil society organizations in Germany. They called themselves Initiative Supply Chain Law, and you can see one of their campaigning posters also here. So yeah, basically this initiative consisted of trade unions, of fair trade organizations, human rights organizations, development organizations, and they really did, yeah, very successful lobbying and campaigning along the process of negotiating the supply chain law. Nevertheless, the supply chain law that came out of that process is in no way perfect, and that is also being further criticized by opposition parties in Germany, such as the Left Party, and also by civil society organizations. So the picture that I have put here is the one of a toothless tiger, because that's what the supply chain law is sometimes being called. So in the end, I think what we have to acknowledge is that having that law now is a small step. It is a small step in a good direction, but then because it brings us from having voluntary measures to having binding measures, so that is the success. But nevertheless, the law could still be a lot stronger, and there could also be more things involved that would actually benefit especially workers in the global south. And I think the biggest criticism of the law is that at the moment it offers no independent basis for civil liability. So that means that at the moment a damaged party, like for example a worker, cannot claim compensation of damages from the company directly. But what they have to do is they have to file a complaint with the authority, the German authority that I had mentioned in the beginning, and then a process will be initiated to inform the company about this violation, and then the company can look into steps on what to do about it. And I think Zina will talk more about this later on. Another criticism is that the German due diligence law is only looking at the direct suppliers, so only at the companies or factories that the German company has direct contracts with. And also it is looking at mostly so-called upstream business activities. So it looks at whatever is being supplied to a German company so that they can produce a certain good, for example, but it is not looking at downstream activities. So that means if a company sells something, then what harm might come from that? Like, for example, if you're selling pesticides, there might be a harm from that. So it is still contested whether this is also something being covered by the law or not. And another thing is that critics of the law are of the opinion that actually the law should also be applicable to smaller companies, starting, for example, from 250 employees upwards. So to end, what I think should be our way forward with the law that we have, like even though it is not a fully satisfactory law, but I think it is still very important at the moment to spread the word on this law, to do capacity building on this law and on the possibilities that it offers. Also, we need to test the law, I think. Like, we need to see if we are trying to make use of it now, how far do we actually get with it? And that's something that RLS is currently doing in a project together with Femnet. And yeah, Sina will also talk more about what has come out of that. And apart from that, actually what is happening this week on Thursday is that the European Parliament is going to vote on the Sustainable Corporate Governance Directive at the European level. So this is also, even though there was also a lot of back and forth and a very strong corporate lobby watering down the law, but still the European directive is in some ways stronger and stricter than the German due diligence law. And that would mean that Germany would probably also need to adapt its law. And apart from that, of course, there will be a continuous evaluation of the law. And yeah, civil society and opposition parties such as the left, not all opposition parties in Germany, but certainly the left, will of course try to lobby to strengthen the laws in the future. So I will leave it at this. I hope this gave you a good overview of the political process, and I'm happy to take up any questions later on. Thank you.
Thanks, Nadia, for this excellent presentation. I can already see some questions coming in your way, but what we will do is let's have the presentations first, and then we will have a question and answer session where we will share all those questions. So till then, all our participants, they can note down their questions or they can share the questions in the chat box. Next, we have Gina Marks. She leads the campaign on the supply chain law. She's from Femnet, and she will be talking more about the different provisions of this law and how we can leverage it. But before she does that, I just want to share one experience. I was actually looking at the response of Indian businesses to this German Supply Chain Act. And there is not a lot, but still there is a substantial literature one can already see in the business papers. Of course, the major response is in the form of a complaint that it will increase their compliance cost. So I found it quite interesting, but from the side of the trade unions, whatever limited interactions that we had with different trade unions in and around Delhi, our sense is that the trade union movement is still coming to terms with this new law, and there is also a general apprehension. Nadia also shared that whether because in history, in our recent history, there have been many such attempts of regulating the supply chains, but often these initiatives have turned out to be quite toothless. So there is a kind of an element of apprehension from the side of the trade unions. But nonetheless, this German supply chain law at least appears a bit different from the earlier ones, where the corporations were basically allowed to self-certify themselves. So, and of course, since it is a new law, a lot remains to be seen. And it also, I guess, it also depends upon how far the trade unions actually leverage this law. They spread awareness and they actually use this law. So next we have Gina Marks from Femnet. Gina, I would like to invite you here and make the presentation. Thanks.
Yes, hello everyone. Thanks so much for having me. I think my presentation will be much shorter and more practical because now Nadia has already covered everything that relates to the whole legal background and political developments that and also the gaps that we see in yeah, my name is Sina. I'm working for Femnet, which is a women's rights NGO with a focus on the garment sector. So we basically only work on labor rights in the garment sector, and with this focus on women. And within this project, we work financed by RLS on this whole procedure of testing the law in terms of how this can be used by NGOs and trade unions in production countries for labor rights violations that are experienced by workers on the ground. And Femnet is also a member of the Clean Clothes campaign. I think most of you might be aware of this, but it is a network of more than 250 organizations, both in production countries and consumer countries of garments and textiles. And we also work together with different CCC partners in the production countries to find labor rights violations that actually fit the German law, which can be a little bit tricky, as I'm going to explain right now. One of the partners that we've been working with is NGWF, so the National Garment Workers Federation in Bangladesh, and I just saw that Amin is also here. So in case he wants to add something to one of the complaints that we have already filed under the German Due Diligence Act, which is a complaint about the Bangladesh Accord or the non-signing of German brands, international brands of the Bangladesh Accord. But I will go into more detail on this. First, I want to quickly show you, let me just share my screen. There we go. And yeah, like a little bit of details on the law itself, like the content of the law. So what we did under the project using the German Human Rights Supply Chain Due Diligence Act to enforce labor rights was to do workshops in the beginning of the project with trade unions and NGOs in production countries. So this is a picture you can see from Cambodia, because actually one of the challenges is of course, to spread knowledge about the law, its existence, but also about the tools that the law provides for trade unions and NGOs so that they can actually use it in their work. So one thing is to, first of all, understand which brands are covered, because since it's the German law, of course, it does mainly look what the brands need to do. So we will have a second round, let's say, of law enforcement from 2024 onwards, when companies with 1,000 or more employees will be covered. But this year it's only companies with 3,000 or more employees. And in the garment sector, there's actually not many. And for a long time, we hoped that the German government would issue lists of those brands and companies that will be covered by the law. But they didn't do that so far. So we did have to do the research ourselves. So we tried to find out which brands and companies are actually covered. So yeah, that is what we did in the beginning. And if any one of you is interested to get these lists, we will be happy to share them. So like Nadia already said, it's not only German brands, but it's also brands that do have a certain number of employees in Germany. So that means that mainly those with a big retail are covered. So all of the garment brands that have a lot of shops in Germany, or that have a lot of delivery employees, for example, like Amazon, let's say. Which is one of the companies that we complained about in the Accord case, which I'm going to talk about in a second. Yeah, so this year we would say that it's maybe 35 companies in the garment sector being covered. So not many, actually. So what right positions does the law cover? It's twofold. It's first to protect the environment, and secondly to safeguard human rights. And with Femnet, we're mainly, and with the Clean Clothes campaign as a whole, we're mainly looking at human rights, labor rights, but I'm anyways going to mention the environmental aspect. And where are these rights protected, they are protected in the company's supply chain. And it actually refers to all products and services that are necessary to manufacture the company's products. So it's quite a wide scope. So starting from the extraction of raw materials and ending with the delivery of finished goods to the customer. So this is, for example, why Amazon would be one of the companies covered in Germany, because there are so many people delivering Amazon goods, packing them into boxes and so on. So it can also be a company that doesn't have the headquarters in Germany. Regarding the supply chain, there is a concept of gradual responsibility, though, which is what Nadia already mentioned. So you have a direct responsibility for your direct suppliers. If you have indirect suppliers, so anything that goes down the supply chain, tier 2 and so on, you have these obligations as a company only if there is already knowledge about risks in the supply chain or violations of labor rights. So this substantiated knowledge means that the company must have verifiable and serious information about a possible violation of human rights or environmental obligations. What does that mean? It means that you document a labor rights violation, basically, or one that might be upcoming. It is not that they have responsibility to look into human rights in the whole supply chain, also for indirect suppliers on themselves, but you have to first let them know that, by the way, occupational health and safety in this factory might be a problem, or in this area, in this region might be a problem, which is where, of course, the labor rights organizations in the production countries and regions come into play, because if someone has the knowledge about rights violations, then it's you. So we see like one of our tasks actually to bring this knowledge that you have, the very concrete knowledge about violations going on in certain factories or areas, to the companies to ensure that they have substantiated knowledge about these violations. And so that in a second step, if they don't act upon it, we can complain about it. So which rights position are concretely covered? They are based on 11 ILO conventions. And yeah, for example, there is child labor, there is slavery or related practices, forced labor. Then we have disregard of occupational health and safety, the withholding of an appropriate wage. That is a little bit, I might be talking about this when talking about the second complaint that we are planning to launch, which is on the withholding of a minimum wage in Pakistan. So the ILO convention on which this rights position is based says appropriate wage. So who defines what an appropriate wage is? We are still thinking about maybe next year or whenever filing a complaint about the non-payment of a living wage. But for now, I think it's easier if you find non-payment of minimum wages to actually file a complaint under this rights position. But the formulation of an appropriate wage could also still leave space to actually complain about non-payment of living wages. Then we have discrimination, so based on gender, age, ethnicity, disability, based on the ILO Discrimination Convention 111. For example, for Femnet, since we are a women's rights organization, we will be looking into gender-based violence, gender pay gap, so mainly discrimination that is based on gender. Also with Indian partners, so we are planning to file a complaint on gender-based violence sometime this year still. And then last but not least, and a rights position that might be of interest to some of you, since you might be working with unions or in unions, is the disregard of the freedom of association, which of course is a rights violation that we find quite often in the garment industry, and that is explicitly covered by the law. So these are the human rights positions that are covered by the law. And then there is several environmental rights that are also, or environmental obligations to the companies that are mainly linked to pollutants and chemicals. So what do the companies actually have to do under the law? They basically have to follow procedures that we already know since quite some time through the UN treaty. And in the case of German companies, many of them have these kind of risk management procedures in place already, but anyways, the law prescribes now to have them. So you have to establish a risk management system, which means conducting a regular risk analysis and appoint someone within the company who's actually responsible to do that. So responsible for due diligence, a so-called human rights commissioner. Then for your direct suppliers, you have to take preventative measures to address these risks based on your analysis. For your indirect suppliers, which is mostly the case in the garment industry, you have to only take preventative measures when there is knowledge about violations. Then you have to establish remedies if there's violations that you know of, and set up a complaints procedure within the company, and document and report all of this, what you're doing right now. So what needs to be understood is also the time aspect. Like we said, the law has just come into force 1st of January this year. So they don't have to do all of this at once. They have to do it step by step. So what they have to do now is to basically do the first two things: establish a risk management system and conduct regular risk analysis, and appoint a person who's doing it. That's actually the first step, I would say. Also, they have to set up a complaints procedure. But what they don't necessarily have to do is to already take preventative measures, right? So what you do first is to see what risks do I have to address. And then once you have done your risk analysis, you have to take your measures. For the complaint that we filed on the Bangladesh Accord, this is now getting a bit tricky, because we said, well, actually, the Accord has been there for 10 years. We have been telling them, the brands, since 10 years, please go and become a member of the Accord. We can already, like how come that they shouldn't have substantiated knowledge since a long time? They know about the risks in Bangladesh since a long time. They know about the measures that we are telling them to take since a long time. So they could actually take the measure of becoming a member of the Accord this year already. And we're still in negotiations, let's say, with the German authority to whom we submitted the complaint, whether this is the case or not. But yeah, it takes the testing. There's a lot of interesting graphics appearing on my screen. Okay, so, but this is what the company needs to do. And also, Nadia has already mentioned the Federal Office of Economics and Export Control, the so-called BAFA, which is the authority that is implementing the law. And they're also the ones monitoring the law. So they are basically the authority to address when you want to hand in a complaint, or if you want the German authorities to become active towards a company. So for a complaint, a request by the actually affected person or organization is necessary. So that means that if you have a labor rights violation in a factory, that officially it wouldn't be you or us filing the complaint, but the worker in the factory whose rights have been violated. Since we, of course, often have problems with workers not wanting to step forward for this kind of thing, they might be afraid of for their safety. And yeah, there's many reasons why workers wouldn't want to actually be named. Also, you could, as an organization, file the complaint on their behalf. With the Indian partners that we work with, we had the problem quite often that many of them are afraid to lose their registration in the context of FCRA. So we can also, as German NGOs, do that process for you. It needs a power of attorney then, so that we can step in and file a complaint to the BAFA on your behalf, on the worker's behalf. But the actual, like the more down, like the concreter it gets, if it's the worker who's actually filing the complaint, the more information you will get about the status of the complaint. So what needs to be done once you have considered, okay, maybe Femnet is going to hand in the complaint for us, you need to establish a connection between the company's activity and the violation, okay? Because you're not complaining about the factory, you're complaining about the buyer. So there needs to be somehow a link between what the buyer is doing or not doing and what is happening in the factory. Usually it's actually quite easy. You can pinpoint many of the violations that are going on in factories to the purchasing practices of brands, but it's still, you still need to think about it. Of course, you also need to know, and that's one of the big challenges, the connection between the factory and the brand. So what can the BAFA do once the complaint is filed? They can take very different range of measures. Actually, they can summon people, they can require the company to, let's say, create an action plan to terminate the violations within a certain time frame. They can require the company to implement other concrete measures, which includes the payment of severance and remedy. Also, they have the right to access the company's sites to examine documents and records, which might also be the case if you only have, well, you only think that a company might be buying in a certain factory, but you're not sure. You could still hand in the complaint, and then the BAFA will actually find out whether the brand is sourcing in the factory or not, because the brand will have to show their factory list to the BAFA, even if they are not disclosing their supply lists to the public. So actually, this first limitation that I was talking about, the link between brands and suppliers, is not always easy to establish. I mean, this is a problem that we stumble upon a lot when we actually want to find a factory that is supplying to a certain brand that we don't know. Maybe if the supplier lists are online, we only know they have been supplying to them last year, for example, but they might not be supplying to them now, and all of this. But if you have an idea that this, oops, I don't know why
Hello.
Hello.
Zina, can you reshare your screen? I'm so sorry. So there was some problem with the graphics. So can you try resharing your screen again?
Yeah, sure.
Yeah, I'm so sorry. Yeah.
But the host has deactivated that.
Yeah. Okay. Yeah, I've done that. So can you reshare your screen?
Oh yeah, there we go. Yeah, so actually, in our experience, establishing the link between the brand and the supplier might be the biggest challenge, because many of the local trade unions or NGOs, they work with local tools, of course. For example, going to the labor ministry, a labor court, using these kind of tools that you have on a national level, and you don't necessarily need to know which brands are sourcing from a factory to complain about that factory with the local structures. So what the local trade unions kind of need to do is to be interested, at least in this link, when they document labor rights violations. Try to ask workers, for example, if they know what labels are being sewn in into the products. For those brands that do publicly disclose their supplier lists, of course, we can also do the job. Yeah, let's say you send us the name of the factory that you have problems with, and we check whether we can establish the link to a brand that is covered by the German law. And in the end, actually, the German authority, the BAFA, will look for the proof. Okay. It also brings, when we look at the chances of this law, our experience is that the dialogue with brands is actually much easier since the law has been announced. So it's more probable that the company will respond according to their knowledge that they will be legally required to get into dialogue with you. And well, of course, the complaint at the BAFA, which I will show you in a second how it actually looks like to do this, might hold sanctions for the company. And as Nadia already said, one of the big gaps of the German Supply Chain Act is that you don't have civil liability, which means that you can't sue a company based on the German Due Diligence Act. But you can, of course, still go to court if you have very severe occupational health and safety cases, like the Ali Enterprise case or the Rana Plaza case. In this case, of course, you can still go to court. For all the other, let's say, more everyday labor rights violations, you would have to file a complaint. I will quickly show you how the complaint procedure looks like. Sorry, I have to quickly share my screen again. So one of the complaints that we already launched, like I said a second ago, was a complaint case on Amazon and IKEA, who have not signed the Bangladesh Accord, still not. And we filed the complaint like a few days before the 10th year anniversary of the Rana Plaza tragedy, saying that we would understand that IKEA and Amazon would both have to sign the accord as the best tool out there to fulfill your human rights obligations in the area of occupational health and safety, and substantiating this with cases from Bangladesh where factories that are not covered by the accord, that are supplying to IKEA and Amazon on the basis of interviews taken with workers, that in these factories we found labor rights violations related to safety, related to freedom of association, which is both something that the accord covers. So just for you as an example of the kind of cases that the accord would, that the German Due Diligence Act would cover. And this is the report a complaint form. I just wanted to show it to you. I also put the links into the PowerPoint so you can have a look at it. So this is actually how you would be able to hand in a labor rights violation that you document to the German authorities. So it's an online form where you can put both information on yourself as the complainant. So that would be either me if I do it for you, or it would be you if you want to do it on your own behalf. It would have to be the worker if you want the worker as an individual to step up here, or you leave it open and do it completely anonymously. That is also an option. Then you need to fill in information on the company you wish to file a complaint about. So that means that would be the company, the brand, the German or international brand that you want to file a complaint about. And then what you would have to do is to actually just quickly give a description of the violation that you have been coming across. So human rights complaint, for example, let's say disregard for occupational safety and health, then you would describe it something like, I can't form a union because the management won't let me, is actually sufficient. Okay, so it doesn't have to be a very sophisticated report, but it's rather a straightforward online form. And then the German authorities will have to dig into this case and see whether the rights violation that you're describing is something that they can prove to the company and ask the company to stop it. I will stop here because we're already quite advanced in time, and I'm happy to answer your questions later on.
Yeah, thanks, Gina, for this very comprehensive presentation. I have a couple of questions from my side, but let's have the third presentation first. A few comments, if you have any. You can also have to the participants. It's not necessary that you only post questions. You can also ask. You can also have your comments. And now we have our third speaker, Professor Devanathan. He has written a number of articles. He has also contributed to a number of edited volumes on global supply chains. And he is also one of the editors of this series called Development Trajectories in Global Value Chains. Professor Devanathan, yeah.
Thank you. Thanks to CEC and RLS. I'm happy to be here. An apology, I had noted it wrongly in my diary as starting at 3 o'clock. And I don't know how I made that mistake. But anyway, fortunately, I got a call somewhat before that. But anyway, I'm a bit late, so apology for being late and not hearing fully the earlier presentations. I would just take a few points with regard to this German Act. First point is that the passing of this Act is an admission that what they all worked on, that is private regulation by brands themselves through their codes of conduct, does not really work, which is what our research shows at different parts in different parts of the world. But now the passing of this Act is an admission of the fact that so-called private regulation does not work. Of course, in our own countries or in Germany itself, obviously the German state or the working class does not rely on private regulation, but has acts to enforce those laws and regulations. So that's the first good point. Secondly, there are penalties in this act. So that's another good point. I saw that there are can be fairly substantial penalties, though I don't know how the penalties would be calculated, but they can even go up to 2% of the revenue of a company, which is a fairly substantial amount. But third, I was very disappointed to read the details, particularly on living wages. You know, last year when I was working on this topic, I was very happy to see a statement by the German minister, I forget which minister, saying that they will support living wages everywhere. It was a joint statement by the German and Dutch ministers. But when I look at this act, it's a complete travesty of what is a living wage. The act says the adequate living wage amounts to at least the minimum wage as laid down by the applicable law, and apart from that is determined in accordance with the regulations of the place of employment, presumably the country of employment. Now, we all know that living wages are much below minimum wages are much below living wages. Calculations by the Asia Floor Wage Alliance and others show that it can vary from 25% of the living wage in Bangladesh or Sri Lanka to about 35 in India, perhaps 40 in China, 40, 45, but nowhere is it anywhere near the living wage. So while they say we are standing for living wages, but by defining living wage as the minimum wage, they've completely thrown away the idea of a living wage and allowed their brands to carry on their contracting practices, which is always based on living wage. I was hoping that there would be some, obviously, they don't want to put their brands into trouble by making them not contract at living wage, at minimum wages, but contracting at a higher wage than the minimum wage. It's very disappointing. I hope our German friends and others will take this up, that this is a complete betrayal of the idea of a living wage and something that completely erodes the entire act, because the wages is the key part of the whole bargaining area. Of course, there is sexual violence and other things, but we know that wages is such a big part of the entire contract, and that is being thrown away by this very callous manner of saying that the living wage amounts to the minimum wage. That's a very important thing. Now, the third point, which some others mentioned, but I see in discussions with various suppliers, that who will bear the costs of all of this type of due diligence? That means, everything has a cost. So who will bear it? Now, we have a situation in the garment industry, which I would call a global monopsony situation. Ashok Kumar, who is at London and from Bangalore, he started using this term, global monopsony, and I and some others also use this term, global monopsony. We know monopoly, but we don't really know monopsony very much. But monopsony is the other side of monopoly. Monopoly is where there are one or few sellers and many buyers, and therefore the seller has some kind of power to set prices above market prices in the market. So they become a price setter. Monopsony is the other side, when you have a single or few buyers and many sellers, which is what you have in, say, garments and all of these global value chains. So we have a few brands who are the buyers, and you have a large number of suppliers who compete among themselves, not only within the country, but across countries, to try and get a share of that business, of that contracted supply. And this monopsony allows the monopolist, like whether it's Adidas or any of the other German brands or others, to push down prices that they pay to the suppliers. Now, recently in studying the supplier contracts, I was surprised to find that they are actually moving from what was a time-honored method of calculating prices, which we call FOB, or free on board. And now they're moving towards, in some cases where the suppliers are weak, they're moving to landed cost, which is not just free on board, but also includes any taxes or any other fees that might have to be paid at the port of entry. Therefore, they're reducing further the margins that the suppliers get. So this leads to a very important point. How do you decide who should bear what portion of the costs of observing human rights? First of all, we have to look at what are the profits being earned in this value chain. Who earns how much? And on that basis, we will have to see who should pay how much. Obviously, now when I looked at the brands, and I must say when I discussed, or when a friend of mine discussed it with suppliers, they were shocked to know that brands actually earn gross margins of about 40 to 60%. These are not small profits. I have over here the figures for not the German brand, but I have, well, Adidas is at 50%, H&M is 52%, Zara is 60%, Louis Vuitton is 69%, and C&A is 48%. So they all earn very high gross profit margins based on the low prices that they pay for the manufactured garments and other inputs that they secure from the suppliers. Look at the gross profit margins on the other side. I have figures here, not for particular companies, but the annual survey of industry in India gives us for the industry as a whole, which is basically the export, the garment factories, which are all export-oriented, export-based. Garments, in the same time, the gross profit margin was 6%. In leather products like footwear, it was 6.7%. So you have 6% is barely able to carry on your business. It's not. It is even lower than the rate of return on a fixed deposit. Okay, that's what it is. So you're earning just enough to keep the company going. So who should pay for the cost of the requirement, that is, of human rights, of ending human rights violations? I would say it clearly has to be, and this is what the German law, of course, doesn't say anything about it, and therefore the suspicion on the side of the buyers that all the costs will be put on to them, which some of it they should bear, of course. I mean, you can't be doing things like having rapes and sexual harassment in your company and not think that you are not responsible for it. But even in the matter of sexual and gender-based harassment and violence of various kinds, why is it happening? Is it just a matter of men attacking women or men in positions of authority attacking women? No. Our analysis, which we put forward in the book on reverse subsidies, is that gender-based violence on the shop floor, or the work floor, particularly in garments industries, is a method of supervision. It's a method of getting a high rate of work out of your workers by threatening them in so many ways. When we try to make a kind of rough quantitative assessment, well, verbal harassment and abuse, every worker faces it. Sexual abuse and verbal harassment. Physical sexual harassment and abuse, at least 30% of women workers say that they have faced it. So this is, and the output required is so high from these workers. And why is a high output required? That we have to lay the blame at the fast fashion, which is now ruling the world. That you have very short lead times. Lead times have been going down from about 90 to 100 days. Now they're down to 30 to 35 days. And the margins, already told you, are very low. So how do you get, and of course the workers earn a pittance, they earn just the minimum wage. So they have to do overtime if they are to earn enough to even support themselves, leave alone their families. But along with that, they're also subject to the high rates of high quotas of work, and therefore the high levels of verbal and physical sexual abuse and harassment, which is a form of supervision. So unless we go to the roots of these problems, we are not going to be able to really get, some way of ending these human rights violations. So I will now just take 2 points. I would like to reiterate the point that, look, we really have not looked at the structure of these global value chains. We said, okay, these are brands and these are suppliers and they bargain with each other. But at an economic level, we have to say that this is not just a normal bargaining on the market. First of all, these are not suppliers who produce garments and then take it to a buyer and say, okay, do you want to buy these garments? What price will you pay for them? No, they are not. It is not as though India or Bangladesh suppliers produce these garments and sell them to the German or other brands. No, they are contracted producers. They produce on contract. They are not sellers on the market. When you go to the market, you buy a brand, yeah, that is a seller on the market. But when Adidas or Zara buys from their suppliers in India or Bangladesh, they're not buying it on the market. They are buying it on the basis of the contracts. They're paying for it, rather, on the basis of the contracted production. So we should really consider these supplier factories as being the production departments of the brands, and not as independent agencies operating in the market for goods and services. They are not. They depend on them. And that's why there is this monopsony position, which completely weakens the sellers in the bargaining with the buyers. Now, what's the way forward? I would like to put for there one thing. We've been spending 30 years, 40 years and more trying to do something. Yes, there have been some advances, some attempts at ending child labor, a little bit on sexual harassment, a little bit on wages. At least minimum wages are paid. Earlier on, minimum wages were not even being paid to workers. So, but it still remains at the bottom. I mean, the wage remains at the, it's a very sticky floor. You can't get off that minimum wage level anywhere in the world, whether it is Turkey or Sri Lanka or India or China. Garment wages are basically minimum wages. So how do we get out of that floor? So we need to have some kind of global compact. We need to have some coming to a global manner of dealing with this. There is one way of where this has been dealt with, and that is what is called the ILO's Maritime Labor Convention. You all may not be familiar with this, but I would urge you to get familiar. You'll find it, of course, on the website. The Maritime Labor Convention is the only ILO convention which is very different from every other. It is a requirement. All 95% of ships registered on the earth come under that Maritime Labor Convention. And there are very important things in it. First of all, it has an implementation mechanism. This is not just like other ILO conventions that, okay, you can register a complaint. No, it has an implementation mechanism. In any port of call, if the port authorities find that either labor or environmental issues are being violated, they can impound that ship. They can stop that ship from sailing, and therefore, it will be very costly to that. So this has had to make some changes in the maritime labor condition. Now, the Maritime Labor Convention has 3 levels of wages. It's not as though there's a one wage fits all. Obviously, you cannot have the same wage for a sailor in a German ship or in Germany, and a sailor for a Liberian ship, though owned by the Germans maybe, or somebody else. And so they have 3 levels of wages. One is a wage for the low-income countries. Second is a wage for middle and emerging countries like China and India. And third is a wage for high-income countries. Now, there should be some kind of graduated wage system like this and a mechanism to implement it, and other aspects of human rights concerns in global value chains. So I would urge that we need to move in this kind of direction. Yes, we take whatever is positive in this German law. We use it to try to file complaints. And I don't know why there is no civil liability. I was reading the law. I'm not a lawyer, so I don't know why it says that there is no civil liability if for any violations under this act. So what does that mean? You let them off the hook. That's what I understand it as being. You can't go and file a case against them. all you can do is to go into this so-called complaints procedure. So I would end by saying that, yes, there have been a little bit of has been done by this German law. It is good to use it, like trade unions would use everything that is to their advantage. But the biggest flaw in it is that it has completely made a mockery of the idea of living wages by saying that living wages are minimum wages or whatever prevails in that country. And finally, that we should look at ways of getting to a global compact which will allow us to take forward the implementation of workers' human rights in global value chains. Thank you.
Thanks, Professor Nathan, for this very strong and powerful presentation, and for pointing out at the very core of the problem, that is the monopsonic nature of the supply chain, where unlike the textbook understanding of a market, the nature of the relationship between the buyers and the brands are not really equal, and they are organized in a very hierarchical and unbalanced manner. And in fact, that remains a challenge for this German Supply Chain Act as well. So before we open this session for question and answer, let me just put two brief questions for Saina. I had some more, but because we are already running very late, so let me just limit myself to two questions. So can you talk a bit more about this difference between appropriate and minimum wages in terms of its relevance for raising complaints? And also, I was reading the Act, so it does talk about the trade unions, but in terms of enforcement mechanism and also in terms of how they can actually raise complaint, I was a bit unclear about the place of the trade union. That I mean, how the trade unions are placed in this Act. Can we actually say that the Act makes trade unions or some form of association mandatory for the enterprises, or is it just more advisory in nature? Because we have so many examples of unions, fake unions formed by the factory owner himself. So in that way, what does the Act actually envisions for trade unions? Yeah, but before you can answer, let me just read out a few more questions here that I got in the chat box. So the first question is related to so the question is, to fall within the purview of this Act, will the employees will have to be physically based within the territory of Germany? Will the workers have, can workers who are based offshore be counted too? So that's one question. The second question is related to, so it's more of a comment. So what is the logic of a UN Treaty on Human Rights in Supply Chains when we already have the ILO protocols? So that's a comment. Then somebody requested to talk a bit more about the implementation challenges of this Act. And then we have another comment. It is true that minimum wages are much more lower than living wages, but the struggle for hiking minimum wages will have to be undertaken in supplier countries. So these are some questions and comments. So maybe you can take up the questions in the first round, then maybe we can come for a second round. Yeah.
Sure. If I had known that Amin and Nasir are both here, I would have taken for them some time to talk about how it feels to prepare a case for the German authorities, because it's a bit tricky, of course. But maybe to start with the question of the employees, the employees, 3,000 plus this year, 1,000 plus next year, would have to be based in Germany. So that's what I said about the, in terms of garments and textiles, it's mainly those who have a big retail base in Germany, so shops in Germany. And it's also a little bit tricky sometimes to find the right data. One example would be the Pakistan minimum wage case, which Nasir was mentioning in the comments. We wanted to actually, for both the Accord case and the minimum wage case in Pakistan, we wanted to target Tom Taylor. And it turned out that after we did research into factories that are supplying to Tom Taylor, the brand is actually too small. So we had to drop them, and we already put quite some work into it. Of course, we did notify Tom Taylor about the rights violations that we found to create substantiated knowledge with this brand, to then file a complaint next year once they fall under the law, because it's going to be more companies that will fall under the law next year. For the question of the wages, which I think is, like it was mentioned, at the core of human rights and the supplier brand relation, this is one of the more tricky parts, because the German law says adequate wage, but then since it uses the ILO Convention on Equal Remuneration, in this ILO Convention, an adequate wage is said to be at least the country's minimum wage. That means that for wage cases, we can try on a campaign base to file a complaint for non-payment of living wages, pinpointing this to purchasing practices of brands, which was mentioned before. But it's of course easier to try to find non-payment of minimum wages, which in Pakistan we try to find data on. And this minimum wage is always linked to the national minimum wage. So you, as the experts on the national minimum wages of the countries you're working in, would have to know what does a minimum wage in your country exactly mean. And it's actually quite easy often to find non-payment of minimum wages if you look into the details of the wage. For example, the difference between a basic wage and the actual income. Which is also something that we, for example, for Pakistan, found that you might receive the total amount of money that would be the minimum wage in a country, but then this is including overtime, let's say, or this is including certain bonuses, but the law says that the basic wage would have to be a certain amount. So if you really look into it, then maybe the minimum wage in many cases isn't paid. So what was the other questions again? So the same is true for the question on daily wage labor. So if there is a provision in your national law on the minimum wage for daily laborers, then you could also, that the German law would then take the national law of the production country as the basis for the adequate wage. So you would have to look into it. What is the daily wage, minimum wage for daily laborers according to national law? And is that being paid in the production unit you're looking at? Okay, did I miss any question? You were listing quite many. I think you mentioned the role of trade unions.
Yes.
Yeah, I think the point is the German law talks about freedom of association. And of course, this is a freedom of association and not a requirement of association. So you can't tell a brand that you can only produce in factories that do have a trade union and then give them the task on top to check whether that's actually a yellow union or a proper union. So if a union in its role as an institution feels that its rights are being violated because you cannot organize workers in a certain factory because the factory management wouldn't allow for it, then you as the union can file a complaint yourself, being the institution, the legal person whose rights are being restrained. The same goes for a worker who wants to organize but cannot. But of course, you can't tell a brand that you will have to have a union in all the factories that you're producing in.
Thanks. So I open the session for questions from our participants. Mr. Anichur Haq, you wanted to ask something? Please unmute your mic. Anichur Haq, you can ask your question, but you have to unmute your mic. Okay. So anyone else? Oh.
Hi.
Yeah, Lokesh, yeah.
I also have one, not a question, like a query kind of thing about to Zina. So what do you have, the response of the German Act in other countries such as Vietnam, Cambodia, etc. Do you have some interaction with those countries also? So if you can share their response on that.
Yeah, we had workshops with partners in Cambodia, like already 1.5 years ago. It was one of the first countries that we went to do workshops. And I think the point with the German law for most unions and NGOs on the ground is whether in your strategy to advance labor rights, the international arena is like an arena that you want to play, because it's only one tool that you can use, of course, to try to advance, to implement labor rights. And some unions focus mainly on national strategies. And it takes quite some resources to change that strategy. So for some of the unions that we talked to, the thing was that we told them, you will have to be able to establish the connection between the supplier and the brand. So if you don't know which brands are sourcing from the factories that you are organizing workers in, then this tool of the German law will not be of much use to you, because the German law focuses on the brands. So the mechanism of this law is to say, either you find a certain mechanism of what a company is doing is causing labor rights violations in the factories that you're working with. And then you can say, let's say the price. We feel that the purchasing price that a certain company is paying in a factory is not enough to either establish safety mechanisms, to pay a living wage, to have monitoring mechanisms that would prevent gender-based violence and harassment. And this is why we want this company to pay actually a higher price to a factory. But if your main strategy, for example, is to go to the Cambodian labor court to complain about a supplier, about the factory management, then you would have to change your strategy to be able to use the German law. So in Cambodia, most of the trade unions that we talk to, they are not working that much on the international level. So this is why we also mainly focus on CCC members now, members of the Clean Clothes campaign, because they are already used to establishing this link to work on this basis of trade unions working on the ground together with NGOs in the headquarter countries of certain brands to be able to squeeze from both sides. Because yeah, this is basically focusing on what the brands are doing, this law.
There are two further questions from Sana Ahmed. So the first is, could you please compare the German Supply Chain Act with the French due diligence law? And the second is there any discussion on the role of automation or AI for traceability and transparency in the supply chains?
Professor Devnathan also
Yeah.
raised.
Can
Yeah,
I
please.
just, because there's a comment here, it is true that the minimum wages are much lower than living wages, but the struggle for hiking minimum wages will have to be undertaken in supplier countries. That's only partly so. The point is that there is a difference between export production in global value chains and production for the domestic market. As I pointed out, the margins of the suppliers are so massive, 50 to 60%, and this is based on their monopsony position, and that should have some relation to wages. In fact, this was the theory put forward a long time ago by the Polish economist, that wages really depend on the degree of monopoly. So in a competitive sector, you will not have that high wages as in a monopoly sector, because the monopolist is a price setter. They can set a price of cost plus whatever margins they would like to have. Of course, there is competition even between monopoly, so there's a degree of monopoly, but there's a lot of scope for them to actually pay higher wages. Now, you would know that there are a number of suppliers in some in the Scandinavian countries that work with the Fair Wear Foundation, who include living wages in their contracted costs. So they include that. Now, either you can deal with that in either of two ways. You pay the higher cost, either you increase the price of your product in the market. Some companies increase the price and I put a label saying, look, we are asking a higher price because we are paying a living wage. So if you support a living wage, please buy this product at a higher price. The other way is to accept a reduction in your profit, which is also something. I mean, if Zara's profit were to go down from 60 to 58% or 57%, would it really make any difference to the owners of Zara and whatever incomes they may earn? Now, the point is that when you have the tyranny of the stock market, then it's a different thing, and the immediate short-term price value. So there are different ways in which one can go about it, but you can't have only individual actions. You will have to have some kind of regulation. That's why I suggested that we should really think of how to move toward a global regulation through, and the only possible avenue for that is the ILO, through an implementable convention like with the Maritime Labor Convention. Thank you. I just wanted to make this small intervention on living wages.
Yeah, Simon.
Yeah, regarding these questions, regarding automation and AI, I would leave that aside because I don't think for now it has any link to the German Supply Chain Act, in that sense that there is no provision in the Act, which is a very big gap as well, regarding transparency, which is one of the main problems, especially for the work that we are trying to do with partners together, because if you don't have transparency about the supply chain, then of course establishing the link between the factories and the brands is very difficult, and makes the work much more difficult if you want to hand in complaints, if you want to tell the German authorities, see, look, this is the risk that we are facing in the factories that we're working with, and this is related to this and that brand. So unfortunately, no transparency provisions in the German Supply Chain Act. So I would leave automation and AI out for now. And regarding the French due diligence law, I would also leave that out. We do have a table, and I'm very willing to share a PowerPoint that I did together with our partners at ECCHR, who are the legal experts, where we did a comparison between all the laws that Nadia was mentioning in her presentation in Europe. So it's not only France, it's also Norway. And within the Clean Clothes Campaign network, we actually showed this to our partners, saying, our understanding is that you do not necessarily need to know all the legal differences of these laws, but you would maybe send your case to the CCC network, and then the European partners would have to see, does that case rather fit the German context, the German law, the Norwegian one, or the French one, because they do have different strengths and weaknesses, and also different brands that would be covered under these laws. Due to all of this complexity, of course, the European Act is the one that we are looking at with a lot of interest, because that would overrule all the national laws. And for now, the draft looks better than most of the national laws that are in place already. In a nutshell, I would say that the French law is weaker than the German one.
In fact, I had one question for Nadia also. So in the context of the European initiative, has there been, can you talk a bit more about the political initiative in this context? Because as far as I understand, the criticism from the left in the context of the German Supply Chain Act is in terms of the absence of civil liability and a threshold and so on. So can you talk a bit more about this European initiative and how the left forces are pushing for a law which addresses these concerns?
I can try to do that, but to be honest, I cannot say much about it. And maybe Zina is able to say more about that. So I think at the European level, the same thing or a similar thing happened then also on the national levels, in terms of there's of course a lot of different interests coming together when it comes to negotiating such kind of laws or directives, mostly because of corporate actors being afraid of too many burdens being put on them that might hinder their business activities. So that is a lobby that had to be fought on the national levels, and that also needs to be fought at the EU levels. Nevertheless, at the EU level, they really managed to come up with a very progressive and rather strict directive, which they will then vote on Thursday in Parliament for. And so, yeah, of course, there's also things that still could be improved when it comes to that draft and that legislation. But anyway, it is again a step towards an even stricter regulation.
Thanks. We have our last question from
Mayur. I have one question. question. So it is mainly regarding ensuring the accountability of the buyers to the supply chain. I guess Zina had mentioned about how the coverage of Act is limited towards upstream or direct suppliers right now. And when we speak about indirect suppliers, some sort of substantiated knowledge she spoke about. So how do we also include the workers, human rights, who are associated with lower tiers of supply chain, including the home-based workers? I mean, I feel that they also form a major fragment of the manufacturing process. And how can they use or the aspect of substantiated knowledge about documentation of any sort of violence or any sort of actions that lead to that goes against their rights. So how do we see this supply chain act coverage in these areas?
Well, actually, their rights are well protected. The point is, will we be able to find the link between the home-based worker and the brand? So, for example, for those brands that are covered by general framework agreements, the trade union federations usually receive the entire supply chain suppliers, including home-based workers, as far as I know. So for the big ones like H&M that have GFAs with unions that you might also be working with, it could be possible. For others, I think it might be very difficult. If you do have the information from the workers, for example, they sue in the label or they see the label in the process of work, and you see, okay, this is an international brand, then please send us the case and we will try to file a complaint, because of what we do right now in terms of filing complaints is trying to talk to the German authorities about what this sector looks like. I don't think right now in the garment sector, the law will actually help to bring fast solutions for single workers. What we can do is to get a dialogue with the German authorities, make them ask the right questions to the brands, because they are also, most of the staff of the German authorities, they also just started working on this. So they might not understand all the details of systemic labor rights violations within the sector. So for me, in my eyes, a case of labor rights violations for home-based workers would be very good to make clear the complexity of subcontracting and so on in the sector. So if you find a case, for example, where home-based workers are not properly paid, or where non-payment of minimum wages can be linked to lack of contract, for example, this would be something that would be covered by the law. Substantiated knowledge means that you document this case, you give it to the brand first, you say, hey, this is what we find, this is what we want you to do to stop this violation from happening, wait for them to react, and if their reaction is not appropriate to end the violation from happening, then you file the complaint. So the substantiated knowledge needs to be there first. The brand needs to know about what's happening. They need to be able to react. If they don't, you can file a complaint.
Yeah, okay, thank you.
So we have our last question. I guess this one is also directed to Gina. Do you see any possible impact of the new carbon border adjustment mechanism on the supply chain due diligence? Could that put more pressure on suppliers for ensuring cost of labor and environmental violations?
To be honest, I don't know. I can't answer that question. Maybe someone else has more knowledge about the links between the two.
If I can say a bit on this, the same question is who will bear the costs? If let us say 60% of the total emissions from garments production is very high, and 75% of that is at this stage of manufacture. Now, of the garments manufactured in global value chains, if 80% are consumed in the global north, then should the consuming countries not pay 80% of the cost of reducing carbon emissions? Why should that be put on the global south, which are the manufacturers? So I think this law about the carbon tax or the adjustment can be very much used well, that is the way it is meant to be used, but there will need to be a change in terms of who is to pay, as it is generally in the whole climate change discussion. Who will pay for the costs of mitigation? I'm putting a very simple point here. Those who are the consumers. If you consume 80% of the garments of the world, then you should bear 80%, not garments in the world, because there are others outside of these value chains. If you consume 80% of the garments produced in value chains, then you should bear 80% of the cost of mitigating the carbon emissions in those value chains. So that is the manner in which these costs should be shared between the global north and the south.
Yeah, Rajiv, you wanted to say something?
No.
Okay, oh, sorry. I saw your mic open.
Oh,
So, yeah, Lokesh, you wanted to say something?
No, I'm just.
Okay, okay.
Professor
So,
David's point.
so it's already 4. Thanks, Nadia, Gina, and Professor Devanathan for this really engaging discussion.
Just one point. Why is it
Yeah.
Nadia and Gina and Professor Devanathan? Can be Dev.
Okay, all right, sorry, yeah.
I just want to add, like, announce one thing if you are closing, Mayur. Can I?
Yeah, please, go ahead.
Okay, as in this collaboration with RLS, will in this year will plan to organize a workshop on this also in Delhi. So we'll contact again different people who can join us for this workshop on this law. How we can discuss more in detail on a one-day workshop on this. So we'll contact you again. Yeah.
Thank you all. Thank you so much for this really interesting discussion. I guess the sense we got is while there are challenges, but this act can certainly be explored more by trade unions, and we can definitely see if we can move towards, at least to some extent, in ensuring decent work for the workers, while at the same time, the long-term challenge, of course, remains, as Dave said, that the asymmetry that is there in the supply chains. Thank you so much. And thanks to Rajiv, thanks Lokesh and Abhishek as well for organizing this program. We will share the video link as well as some of the literature that we have on not only this global supply chain, but also on the conversations that we organize on the question of labor. So we will share all those materials with each of you through the emails that we got today. Thanks again. Yeah.
Thank you.
Thank you, Emma.